Welcome to the iSoftPull Main Course Podcast, where we get straight to the point, the meat and potatoes. Now let's dig in. All right, welcome to the show, Arash.
Thank you, Dan. Good to see you.
Glad to have you on, man. For those tuning in, Arash Sadat is a partner at Mills Sadat Dowlett Law Firm. They're a litigation law firm specializing in business litigation. And today we're going to be talking about litigation, mediation, as well as arbitration. So let's dive right in. Some of our listeners, they've heard of these terms, Arash, and they really don't know what they are. So let's kind of start off by talking about the differences and what is litigation, arbitration, and mediation.
Sure. Well, thanks for having me on, Dan. I'm glad to give your listeners sort of an overview of these things. So you've touched on three different ways of resolving disputes, right? So a lot of times in a business relationship, there's some dispute arises, whether it's, under a contract or, one party says that some other party did something wrong to them. And these are three ways of resolving that dispute. Litigation is the way most of your listeners probably already have in mind. Litigation is you go to court, you file a complaint, eventually you have a trial, and either a judge or a jury says who wins. Arbitration is pretty similar. The difference is instead of going to court, it's done in private with a person called an arbitrator. Sometimes that's a former judge or retired judge. Other times it's an attorney with, expertise in the area that the dispute involves. So for instance, if you have a construction dispute, the arbitrator might be an attorney with a lot of construction experience. The primary difference between that and litigating in court is arbitration is private, right? There's no gallery in the back. People can't just come in off the street and watch. Interested parties can't come in and watch. And the other key difference is it's decided by one arbitrator and not by a jury. So sometimes it has advantages, sometimes it has disadvantages, depends on the case. The final thing that you mentioned is mediation. So mediation is a little bit different than the other two because it's sort of a form of dispute resolution that's informal, right? It's not going to court. It's not each side puts on a case in front of an arbitrator. It's not like that. You basically, it's done by agreement of the parties, right? And what it is you basically sit down in front of a neutral, right? Sometimes this is also a former retired judge. Sometimes, again, it's just an attorney. And that person, that mediator, tries to get the parties to come together and reach a resolution. So those are that's just sort of an overview of the three different ways of dispute resolution. Obviously, when you want to do each depends on the circumstances, and sometimes one makes more sense than the other. Sometimes you're contractually bound to do one, right? Sometimes you enter into an agreement that says you have to mediate before you file anything in court. In that case, that's your only option. So yeah, that's just sort of an overview, though, in terms of like what makes sense in each case. It sort of depends.
So do you get to pick, or for listeners out there, is there a decision like which way to go? Are there considerations? Like, I'm just thinking like as a business owner and an issue comes up, right? And where do I start? I call a guy like you, right? And where do I go from here? Like, what are some things I'm thinking?
First thing you should do for a business owner, and typically when you're running a business, most of your business agreements are going to be under some type of contract, written contract, right? So the very first thing you do is if a contract exists, look at it and see what it says. Sometimes it'll say, this is subject to arbitration only. Sometimes it'll say you have to mediate the dispute. Other times it won't say anything about that, which means you can go to court. Sometimes it'll say you have to go to a certain court and not another one. A lot of that stuff is bargained for by the parties before you even enter into an agreement. So this is something that you can sort of think about as you're entering into an agreement. You can talk to an attorney about whether certain of these provisions are good for the company or not. And it also comes up obviously after the dispute arises, at which point you look at the agreement, talk to a lawyer, see what your options are. But the very first thing you do is look at the agreement, see what it says, because a lot of times it's right in there.
Got it. And so let's assume, just for this discussion, that there's an issue between parties, right? And your client comes to you, one of our listeners comes to you, and they give you this story, this dialogue. What are some of the considerations that a business might not be thinking about right out of the gate, which they should consider on whether or not to move forward with a complaint or mediation, like whether or not even to broach the topic, right?
Yeah, it's a great question. So a lot of these sort of collateral considerations are they're really important, right? So first off, filing a complaint, going to arbitration, going to litigation, um, these things can really distract from your actual business, right? So, for example, you're running a credit software business. You're not in the litigation business. What this means, if you're involved in litigation, is you're going to be dealing with talking to your attorney, dealing with searching for and producing documents, including emails, which can take a lot of time and in some cases can be really expensive. Preparing for trial, going to trial. I mean, all these things distract from what you're trying to do, right? Obviously, the really important thing to keep in mind is like how much is at stake and what are your chances of getting that? Because if there's enough at stake, if it's a bet the company type case, it might justify the type of disruption that I was just talking about. Whereas if it's smaller, maybe you don't want to go through all these lengths of going through all the stuff I just talked about, paying an attorney, which obviously, as I'm sure everyone knows, is very expensive. If there's any way to, those are two things to think about. The other thing to think about is whether or not you're going to have a continued relationship with the opposing party, right? In some cases, you're just done with them. You're never going to deal with them again. So, you can do like a scorched earth type strategy and, let the chips fall where they may. If you're going to have a continuing relationship with the party, you need to think about what effect this might have, right? If I go sue them, if you go sue anyone, they're not going to be happy about it. Right?
Yeah, we're not going to be skipping down the road together.
Yeah, no, for sure. And they're not going to be happy, and that could really complicate your business relationship. So these are some of the things I would think about. I mean, it's easy for an attorney to just say, "Yeah, you got a great case, let's go get them." But even if you do have a good case, these are things you want to consider. And when there are other considerations like this, a lot of times mediation makes more sense than the more formal options, just because that way you could sort of just reach a resolution. Everyone comes together and you move on.
Sure. And so let's talk about, let's assume, burn the bridges. We're going, this guy, we're snubbing our nose at him and he did us dirty. We're going to sue him. We're probably going to win. The opportunity cost is big enough, right? And you win. What happens then?
Another really good question. So it really depends, right? Let's say you get a judgment, right? Let's say you can sue someone. Let's say you sue that party that you're going scorched earth on. You get a $10 million judgment, right? But the guy that you have the judgment against, or the company that you have a judgment against, has no assets, right? In that case, you got this judgment, it's worth nothing, right? Because there's the old saying, like, you can't get blood from a rock. That's the type of situation you're in. You got this entity who you have a judgment against, some business, but either they're not in business or they don't make very much money or whatever it might be, or they're going to file for bankruptcy. So your judgment isn't really worth much. In other cases, that you have a defendant on the other side that can pay, right? Like if I go sue Amazon tomorrow, I am not worried about their ability to pay a judgment. I can get a judgment of virtually any size, and I know that's going to get paid.
Yeah.
So this is one of the things you consider when you start a lawsuit. It's like, even if I win, let's say I spend $200,000, get a judgment, am I going to be able to collect anything? So that's something you need to think about early on as well in deciding whether to sue someone if you're a plaintiff.
Now, what if they do got deep pockets? You just automatically, what happens then, right?
Yeah.
You're on this war path. You got a great case. You go to court, you win, you get the judgment. They got deep pockets. Is there sometimes that comes up like, well, we still gotta collect our money, right?
You're sort of you're in a dream scenario there, right?
Yep.
Because a company with deep pockets, once they get the judgment, they're probably going to pay. And the reason is the alternative for them is really not fun, right? So a plaintiff who gets a judgment can start attaching bank accounts. They can start collecting against assets, right? If the defendant owns real estate, you can actually sell the real estate, much like they would in a foreclosure sale, and get paid that way. It's not, and the other thing is there's you can take what's called a judgment debtor exam, right? So judgment debtor exam is something where you have the defendant who you got a judgment against. He shows up usually in court, and you get to sit down and ask him questions like, "Hey, what was your total income last year? How much jewelry do you own? What kind of cars do you have?" And you find the location of these assets. You say, "Give me your tax returns," something people obviously don't like turning over. You find the location of these assets, and then you just start grabbing stuff. So that process is so intrusive that a party that has money is not going to go through it. They're just going to pay up in most cases.
So, I mean, we just walked through, a lot of high level on all these things, but one thing we didn't talk about is when these considerations is the emotion that goes on through the case. And I think that's sometimes not looked at, right? I mean, even if you do have a good case, and even if they have money and the size is good enough, there's going to be a lot of resentment, right? A lot of sleepless nights, a lot of harboring this. I mean, you're walking around pissed off all the time. It's on the front of your mind. So, how do you deal with? Do you ever talk about that to clients too, or is it just like, if you're willing to go, let's go.
No, absolutely. Definitely talk about that. So, one thing I'll just say, but before I get into this, is like if you're looking for justice, right, from this process,
Sure.
very few clients come away thinking, regardless of the outcome, that justice was served, right? This is it's a long, tedious, and painful process. Usually, people don't walk away happy from it, right? That said, there are emotions involved a lot of times in litigation, right? And that can be especially true in a business dispute with parties that have worked closely together for a while. Those emotions definitely come up. So what my job, I think, is to usually explain to the client, like, you don't want to litigate on principle, right? You want to make a sound decision that's good for your business. In most instances in business litigation, I represent the company, right? So my duty is to the company, not to satisfy the desire of one of its officers or whoever to get revenge or something like that. You know what I mean? So my duty is to say, like, hey, here's what's good for the company. In certain cases, it's like, don't spend a ton of money on this because you're out to get this guy. See if there's a resolution that can be worked out. In other cases, the advice is different because it's in the best interest of the company to pursue a case. It just really it depends on the situation. And I think, generally speaking, emotion is something that you want to put aside in matters like this. It's difficult. I know that. I know when someone did you dirty, it's not something that you want to stand by and allow. But that emotion fades over time. It also fades once you get your attorney's bills, which are
Yeah.
you see bills that start totaling into the 5-6 figures, and you're like, man, do I really want to do this? You know what I mean? So sometimes that's a realization that takes a while to set in.
I do. So we walked through this. Like, I kind of want to drill down into each one of these topics: mediation, arbitration, and litigation. So for our listeners out there, mediation, what is that like? And who is the typical parties that is suitable for a mediation? Like, what is the scenario?
Yeah. So the scenario is usually you have a dispute, some business dispute, two parties to a contract. One of them is saying, like, hey, you breached. The other one is saying, no, I didn't. And the parties have a desire to work it out without going to court. Either they have a desire to work it out or they're required to work it out by the contract they sign, or at least to try. So that's typically where it comes up. It also comes up quite often after a lawsuit's been filed. So the parties get deep enough into a lawsuit where, they've done some discovery, they've collected some documents from the other side, they sort of understand the facts better, and they say, you know what, instead of dealing with the uncertainty of a trial and instead of accruing additional attorney's fees and costs, let's sit down and see if we can work this out. That's almost always an option, right? And you can do it virtually at any time. So that's typically how it comes up, and it's well suited for parties who are really motivated to try and be done with the case and move on and run their business. It's not as well suited for people like we just talked about who are emotionally invested. If you're too emotionally invested, a lot of times there's not going to be a resolution via mediation. Arbitration is probably is appealing if the privacy aspect is important to you, because it's not public. Another situation in where arbitration is appealing is when, if let's say you're a defendant, someone has sued you, and you don't want the case to go to a jury. There's a lot of reasons you don't want a jury deciding your case. Number one is it's really, really variable, right? The universe of what you can be held liable for expands substantially. A jury could award damages that you might not anticipate. They could render a verdict that you might not anticipate. It's very uncertain, and it can sometimes raise the ceiling of liability for a defendant. There's also certain situations in which, for whatever reason, the defendant might not be sympathetic. Some of the things the defendant did may not be sympathetic, and you want to avoid a jury being involved in the case because they're going to inject more of their personal bias, emotions, things like that into their decision making.
So it sounds like litigation is better for defendants. I mean, rather, arbitration.
Yeah, litigation typically is better for the plaintiff. Arbitration is typically better for the defendant. But again, it depends. Another thing to think about if you're going to litigation is what's the venue, right? So where is the case going to be? If for instance, I have a really good venue, let's say I'm the plaintiff and I have a really good venue, like I get to go to San Francisco Superior Court, right? Typically a very good venue for plaintiffs. LA Superior Court, typically a very good venue for plaintiffs. That's going to be much more appealing than if I'm a plaintiff and I'm going to Kern County Superior Court, right? Not as good a venue. So these are things that like an experienced litigator is going to know what the good venues are, if you're actually litigating.
And that's jury dependent, or what makes a venue a good venue?
Good question. So it's the judges and the juries. So judges in Kern County, for instance, tend to be, as you would expect, more conservative than judges in San Francisco or LA, right? That means that in Kern County, as a plaintiff, you're more likely to get your case dismissed before it ever sees a jury. Also, the jury pool is going to be different between those venues, right? The people that live in Kern County typically have a very different mindset and experience than the people who live in LA or San Francisco. So it's another thing to take into account is like, who are the people that are going to be on this jury in this venue? It's a really important consideration.
Got it. And then, so we touched on mediation and arbitration. Let's touch on litigation and who that's suitable for.
Yeah. So litigation is sort of a catch-all, right? If you don't have an agreement to arbitrate with whoever you're suing, that's basically where you're going to end up. That's the sort of default situation for anyone that is wronged, right? For breach of contract, for anything, for torts, for anything like that. So it's and like we touched on a little earlier too, it's typically better for a plaintiff, a sympathetic plaintiff. Like let's say you're a little guy, right? Let's say your company is this small sort of startup, few people, kind of up and coming, and the defendant is some, big bully of a corporation who's got, people on the other side who a jury might not necessarily sympathize with. In that case, your best venue is probably going to be court. It's going to be litigation. So yeah, and then go ahead.
I'm just saying in San Francisco, right?
Yeah.
Or in LA.
So just to give you an idea, so before I started my own firm, I worked for this law firm called White and Case. They're this big global firm. that represents a lot of big companies. One of our clients was Gerber. And what would happen is there was this flood of lawsuits relating to like false or misleading labels on foods. Gerber was one of the defendants in these lawsuits. Every single one of these lawsuits was filed in basically in San Jose, because that's where the plaintiffs, because the conduct is nationwide and the plaintiffs just decided this is literally the best venue for us. This is the single best venue in the United States for a plaintiff to win this case. So just, something to think about, that like really savvy litigators have made that decision when they had their choice of venue anywhere in the country.
Sure. So that brings me to my next point is choice of venue. When what can people do, business owners do, prior to setting out their agreements, prior to starting their business, considering everything we've just talked about for the last 20 minutes? And God forbid, nobody wants to litigate or arbitrate. Nobody wants to sue anybody. But is there any measures that a business owner could take or should take to posture themselves better in the event something arises?
Yeah, definitely. So, in terms of structuring your business, I'm not a transactional lawyer, but I can tell you that you don't want to operate as a sole proprietorship. You want to operate as some type of business entity, whether it's an LLC, C corp, S corp, something, so that you get protection from your personal assets being subject to a judgment. Right. That's number one in terms of structuring. In terms of protecting yourself at the outset of a transaction, you probably want to talk to an attorney. This is a really simple task that won't take an attorney much time, but could save you a lot of money down the road. So if you get an agreement and you look at it, you want to decide, like, okay, should we say that we're required to mediate? Should we say that this case is subject to arbitration if there's a dispute? Should we just say nothing? The other thing to think about is, should we put a provision in the contract that says the winner gets attorney's fees, right? That is a really, really important consideration. I can tell you that's literally the first thing I look at when there's a contract dispute, is that attorney's fees provision. And then I look at the other stuff relating to venue and arbitration. But the thing to think about, this is sort of strategic, right? If you're going to include this, what we call a fee shifting provision, which means the loser pays the winner's fees. If your duty in a contract is basically just to like provide some service, for instance, that you're going to be able to provide for the term of the contract, and the other side's duty is to pay money, you got to think about who's more likely to breach that, right? In the case where the other side has a continuing obligation to make some type of installment payment or pay some money, you really want to think about having an attorney's fees provision in there. That way, when they don't pay, right? Let's say they're $25,000. They owe you $25,000 on this contract. It's going to cost you way more than that to go collect it from them in court in the form of fees and costs and everything. But if you have an attorney's fee shifting provision, you can get not only that 25 grand, but also collect from them anything that you spent on your attorney's fees too. So in other words, it can make you whole. So that's a really important thing to think about and probably talk to an attorney about, is like, who's more likely to breach? And based on that, should we include a fee shifting provision?
So absent the fee shifting provision, what happens?
Everyone pays their own fees. So yeah, there's situations where, you're trying to collect, like I said, 20 grand, and you spend 150 grand in attorney's fees trying to get it. A lot of times it makes it just not worthwhile.
Or even if it's a lot bigger sum, even if it's 150 grand. Let's say you're going to collect 150 grand, but it's going to cost you 150 grand in attorney's fees, and there's no provision.
Yeah. So it really takes away the upside. Now, the thing to think about too is the other side has this problem as well. The other side's thinking, oh man, I owe 150 grand and now I have to spend another 150 to litigate the case. In situations like that, that's where mediation is really helpful. When there's a big, big window of a win-win situation for both sides, you're very likely to reach an agreement in that type of scenario.
So considering all that, and somebody with a problem typically comes to you, right? I just want our listeners to understand what happens. I got a problem. This guy screwed me, and I'm calling Arash. What does that look like? Just give some color, some insights, and what that usually looks like. The initial engagement and maybe some fact finding. What's the process?
Yeah. So the process is like you said, we usually have a call. I try and get any details that I think are relevant to the dispute or the strategy related to it. And then typically in a business litigation matter, I ask for some of the key documents, right? I'll review those documents and then I'll advise the client. I'll say like, hey, here's the situation. I think you have a good case. I think you might have a bad case, or we really need more information. And then we come up with a plan of attack in the short term first, because that's usually what people are concerned with. It's like, what do we do right now? And then from there, we develop a long-term plan. So it really, really depends on the situation that comes up. If you're a plaintiff, usually the next step is to write a demand letter to say, hey, defendant, you owe me whatever, $250,000. Here's why. Pay up by this date or we're suing you. If it's a defendant, oftentimes you're either already in litigation or you're responding to a demand letter or something like that. But yeah, it's really just an initial sort of talk about the case, figure out the strategy, look at the documents. That's usually what happens right at the outset.
Great. Well, this has been a great podcast. For our listeners out there, can you tell us a little bit about who your typical client is? What issues come to you? Not specifics, but generally speaking, what kind of clients do you guys serve and what issues?
Yeah, so we serve clients. The firm has a really broad practice area, but I do a lot of business litigation, clients from all industries. We have experience with clients in the real estate sphere, clients who sell nutritional supplements. We represent some fairly decent sized companies in that sphere, companies in the credit space like yourself. Really the industry isn't as sort of important as the type of dispute. And the type of dispute we can do is that I've done a lot of is contract disputes, interference, like someone interferes with your business, stuff like that. So anything in the realm of what could be called business litigation, we do.
Is there ever a time when a case comes to you and it's not necessarily about money, it's about performance?
Yes, that happens all the time.
Give me an example of that.
It comes up a lot in the real estate context, right? So let's say there's a sale of some commercial property, right? And the seller is backing out. And the buyer is saying, no, I need you to deliver title and possession of this property. That's about performance, right? Because there's no substitute for that specific piece of property. Every piece of property in the world is unique. So in that situation, you can't just, you could, but it's hard to just say like, hey, I was damaged. I lost X amount of dollars from your breach of contract. You say, no, I need that exact property delivered to me.
There's no substitute.
Right? There's no substitute, exactly. So in situations where there's no substitute is typically when you're entitled to performance of that kind. In situations where like money is as good as whatever you lost, courts are usually going to say, well, go get the money then,
Yeah. Well, great. This has been a great show. How do people contact you in the event that they're like, you know what, this has been a good podcast. I want to talk to Arash. How would they contact you?
You can look up my firm, Mills Sadat Dowlat LLP, or you can just Google my name, Arash Sadat. You should be able to find my contact info. I'm out there. I exist on the internet, so should be pretty easy to find me.
Cool. Well, thanks again for coming on the show. Really appreciate it. And for our listeners out there, hopefully you won't have a dispute where you need to talk to Arash. But if you do, you got his contact, and I hope you enjoyed the show. Cheers. Thanks for listening. Subscribe to the main course for straight to the point business insights.